We've been listening to testimony in the John Valerio case out of Nevada, and we'll get back to that case in a minute. But first, we want to jump into another subject we've been talking about for a while here on the LawNewz Network, and that is the case in Colorado that's gone viral on the internet of cheerleaders being forced to do painful splits by a cheerleading coach. I want to play the video that's been running around on the internet like crazy for the last couple of days, and then we'll jump in just a second into our legal analysis of all the legal issues surrounding what so many people are talking about.
No. You're just gonna make it worse. Stop me. You need her inhaler. What's up?
That's what so many people are talking about on the internet these days, and to help analyze the issues surrounding it, we want to bring Mark Tate into the conversation. He's an attorney in Savannah, Georgia. Mark, it's good to see you here on the LawNewz Network.
Good to see you, Aaron.
Okay, so I thought we could start by doing the old law school analysis of what we're seeing there. Here are some of the facts to kick things off. You've got a girl yelling, "Please stop," as her coach is apparently forcing her to continue to do this. The coach, I think, was either pushing his foot or his knee or something into her. The girl's mother did an interview with CBS recently saying that the daughter was afraid of the coach, okay? But the daughter apparently made this other statement saying, I thought it was normal, I didn't think much of it. I don't know what she was referring to, if she was referring to the pain or the training situation, because just about every other coach in the country has come out, at least a professional organization has come out and said this is not the way this should be going. The coach and 4 other school officials have been put on paid administrative leave related to this. I thought we could start with assault and battery.
Yeah. Well, Aaron, one of the very first things you learn when you start your first year of law school, you have 2 different classes you take. You take criminal law and you take torts. And in both of those cases, you learn from the very beginning of law school that a battery is simply an unwanted touching. And you communicate that a touching is unwanted by saying things such as, "Please stop. Don't do that. It hurts." And so I think from either a criminal analysis or from a civil analysis, that gym coach, that gymnastics coach, that cheerleading coach is doing something to girls who are under the age of 18 that is very clearly, blatantly, without their consent. Their communication to him, in my analysis and the way I would look at it if this case came to me to review from a civil standpoint, is that this is an unwanted touching. And I would go further, and in researching a little bit about the injuries that these girls suffered, they have documented injuries for which they received medical treatment, including skin tearing, tendons tearing, and other injuries that were not quite as serious, but certainly including bruising. And so I think when you have a clearly unwanted touching, and I think when that unwanted touching causes an injury like that, I think the criminal code begins to define things differently, and that may, in fact, be an aggravated battery. And so I think what happened here clearly is inappropriate and possibly criminally illegal and certainly civilly illegal. And so the next question, I guess, sort of becomes, who is liable for that coach's conduct other than the coach?
Yeah, I wanted to get there a little bit further down the chain. Yeah. But so battery we know is the unwanted touching. What about assault? The old definition of that, at least the core definition, I haven't looked at Colorado's just yet, but that in most jurisdictions means the fear of an imminent unwanted touch, basically. It's the fear that it's about to happen. Now, the fact that's critical to me in the analysis is that at least the girl's mother did this interview with CBS News saying that the daughter was afraid of the coach. And this apparently happened from student to student to student to student. So if they're all part of the same team And I think there were, what, 5 or 6 of them that were ultimately part of this so-called exercise.
Right.
You know, it would seem to me that there's an assault claim in there too, because if you see it happening to one person, you know, your friend over here, your friend over there, and then you know that it's heading your way. It would seem to me that the assault claim is wrapped up in the battery claim and is also pretty clear to make out. Mark, do I still have you or did I lose you?
Go hand in hand when you talk about assault and battery. And so the assault is simply a reasonable apprehension of immediate physical harm. And I think that you're absolutely right. The girls observing what's happening to the athletes preceding them in the exercise or the test or the coaching certainly see what's happening to their teammates and see that they're placed in harm. But you can also obviously be placed in reasonable apprehension of imminent physical harm by what the coach is about to do to you as he explains what's going to happen before he lays hands on you. So I think you're exactly right. I think from a criminal standpoint, this coach has significant exposure, and you know he needs to hire a good criminal lawyer. And I think that there are defenses. I do think that he'll have defenses to
that's
any charge.
exactly where I was going, because I mean, is there a defense of consent here? If you're on the team, you see it happening to other people, the exercise perhaps was explained to them.
Yeah.
I mean, if they still continue to be a part of it, is consent a defense?
Yeah. I had an opportunity this morning, Aaron, in looking at this and talking with colleagues of mine. I had an opportunity to talk with a professional cheerleader who is now a professional cheerleading coach. And the defense is not a great one, but it is still a fact that cheerleading has evolved into a very aggressive, very athletic sport. And this particular professional cheerleader said, when I first started doing splits, when I was 13, 14 years old, this is the way that our coach got us to the point that we could do them. And it does require a great deal of athletic prowess, and you've got to be very flexible, and your tendons have to be coached into that. And so it may well be, and we don't know because we haven't seen the documents, but it may well be that there is a very extensive explanation in writing. It may well be that this is an aggressive sport that requires coaching to be able to do the moves that we're going to try to show you, and injury is possible, and you consent to it. You know, and then we got to talk about things such as, can a minor consent? Can a parent consent for the minor? At what point can you withdraw your consent? And, you know, coaches in every sport push their athletes. And you don't get involved in a sport, you know, to lay on the couch and eat bonbons and watch Oprah. So you're going to get pushed a little bit. So that may well be that is a jury consideration. It may not get him not charged, but it may be something that a jury out there in Colorado is very interested in hearing.
Yeah, okay, I agree. You know, let's continue on here. I'm wondering if there is an intentional infliction of emotional distress claim and possibly a negligent infliction of emotional distress claim from the bystanders and witnesses. Okay, because intentional infliction is for someone to whom it was inflicted. Negligent is for someone surrounding it who witnesses it and suffers some kind of a harm from it. I know that there's a lot of debate about this negligent infliction, and a lot of people think it's a lousy tort. They don't even think it should be the law. I'm not sure if they have it in Colorado. A lot of jurisdictions have it. The new restatement of torts, which is sort of the restatement that many lawyers look to play out the elements that most jurisdictions tend to recognize for torts. You know, it kind of pushes this theory of a negligent infliction of emotional distress on people who are watching something go by. I mean, do you think these claims might be wrapped up into this mess as well?
You know, first of all, with regard to negligent infliction of emotional distress, it's not recognized in most states as a tort unless there is a physical harm. So, for example, if a parent is bystanding and sees their child go through this, in some states it's recognized if it's a parent. But simply a teammate who sees their teammate going through something, unless they get an actual diagnosis of an injury, like post-traumatic stress disorder, then they may have a claim for negligent infliction of emotional distress. In this case, honestly, I would have a very difficult time believing that this coach who wants his team and cheer squad to win intentionally wants to cause them emotional distress. Perhaps the strenuous nature of the activity is emotionally distressing, but I can assure you that anybody who has ever swam competitively or played football or soccer, their coaches push you to the point where you're going to be physically and emotionally stressed, but you want that to grow stronger in your sport. I don't believe, as crazy and as reckless as it appears this gym coach was, I would have a really difficult time believing that he has this team because he wants to emotionally torture them. That would take him from just a coach who is too aggressive and doesn't listen to girls who are injured, and a negligent one. It would take him from that to somebody who's really kind of a monster. And I don't think he's been suggested to be a monster.
Well, it depends on who you talk to. I'm wondering if, and I was going to keep going with this, what about false imprisonment? That's keeping someone bounded in a constraint that they don't want to be in. Do you think that the severity of the footage and the girls yelling, "Please stop," are enough to get a false imprisonment?
Absolutely. It absolutely has the elements of false imprisonment. It has the elements of kidnapping, restricting someone's ability to leave from an area that they don't want to be in. That pretty much meets the elements of kidnapping. What you're talking about, Aaron, I think, is how aggressive and how infuriated is the district attorney going to be, who's going to be presenting anything for indictment. How furious are these parents? How bad are the injuries? What are the parents' interactions with the prosecutor, pushing them to bring greater charges? I know you're aware that many times it is the victim who changes the prosecutorial footprint in any case. And if you have a very upset and aggrieved victim who gets a lot of attention in an attention-getting case like this, that makes a DA far more aggressive. We had an incident here in Savannah, Georgia. There was a cheer coach, and you have to understand cheer, like I said, it's an aggressive sport, and they're highly competitive teams. There was a cheer coach right here in Savannah, Georgia, and this video went viral. During a cheer session, she kicked a dog, and the dog went flying in the air, and the video got out, and she lost a great deal of business, and the district attorney in Chatham County sought to have her indicted for cruelty to animals. And so that type of thing that gets this kind of attention can really invigorate a prosecuting attorney to, I guess, make a clear statement what the community's morals are.
Now, what do you make of the video where it looks pretty clear from me from the recording that some of the teammates were holding down the person who was being subjected to what apparently was really excruciating pain here? Mm-hmm. Do they have any culpability here, or are they just acting at the direction of the coach?
Yeah, I think that the other young teammates who are being the coach's assistant, I really don't think that they're going to have any more culpability than the coach. I believe the coach was taking and directing them. I really, in seeing that, sort of viewed them more as victims, frankly, because they have a coach who's directing them to undertake these activities. So, yeah, they participated, but they participated at the coach's direction. And I think that by signing up for a camp where you're supposed to polish your skills, you are sort of acknowledging and saying that, yes, we understand that the person that we're paying to teach us has more skill, more knowledge, more talent, more ability about how to improve these athletes. And I think they're simply falling in line behind essentially their drill sergeant at this point.
Yeah. Now let's talk about
So
damages.
I'd be surprised to see somebody going after them criminally.
Yeah. Or what about? I was thinking more from the perspective of civilly. But I'd be surprised if teammates went after one another. I'd be shocked. But let's talk about damages here. We've got torn muscle.
Aaron?
We've got physical therapy appointments for some of the athletes who went through this.
Did we lose?
I can still hear you just fine, Mark. Do we have? What do you think as far as damages here? As I was saying, we've got torn muscle, we've got physical therapy, we've got a potential for punitive damages. What do you think might stick? Folks, it looks like we must have lost Mark, so we'll move back to some of our looks at some of what else we're covering here in the John Valerio case. We'll try to get Mark back on the line. We've been listening to a lot of testimony in the Valerio case. Oh, apparently Mark is back. Mark, do we have you back again?
Yeah, I'm right here. Can
Okay.
you see me, hear me?
Yeah, we lost you for a second there. I was starting to ask about damages. I was about ready to go back to the other case we were talking about. What about damages here? I mean, we've got torn muscle, okay, so we've got clear physical injury. We've got physical therapy appointments that at least one of the girls has gone to try to correct what was inflicted there. And I'm wondering if we got a chance for punitive damages here.
Yeah, I mean, certainly if these young ladies' parents came to my firm and said, we want to file a lawsuit against this coach, I think I would include, not because of intentional conduct, but I think because of his wanton conduct, his gross negligence in proceeding despite obvious complaints of pain, I think I would include a count for punitive damages. That's something that is left to the enlightened conscience of the jury in returning a verdict, and you would be wanting to, have the verdict demonstrate to this defendant that future conduct such as that will not be tolerated. Throughout the states, there have been a lot of modification to punitive damages. In some states, the legislatures have said there's only going to be one punitive damages award for one particular course of conduct. So that would mean whoever got to the courthouse first would be the first to collect the punitive damages. But I think it would be something that would be certainly warranted given the conduct. The question that I would have and would continue to have is, what culpability does the school system have? Are they a proper defendant? Do they have any foreknowledge of this type of conduct? Has he done it before? Have they received complaints before?
You're going exactly in the same direction that I was going there, Mark, because we didn't go to the same law school, just to make that clear, but we were taught the same way. So I'm talking about all this other stuff. You've got respondeat superior. That is the, I'm remembering my Latin here. What's that? Let the master answer, right?
Respondeat superior. Yeah.
Yeah,
it means your supervisor is responsible for you.
Yeah, so they can try to attach the school district here. But there's another interesting fact that popped up in one of the interviews with one of the girls' mothers, and that's this whole issue about whether or not the district knew when they hired this particular coach that he had a track record of trouble, and the mother or somebody, maybe it wasn't the mother. The bottom line is that it was reported that apparently there was evidence on the record that he had been in trouble in another district for doing something similar, and then he wound up in this new district. And those who follow, teacher litigation know that this oftentimes happens. And somebody said in one of the interviews, and I'm trying to put my finger on it in my notes right now, that apparently that was going on. So I'm wondering if we've got negligent hiring or negligent supervision rolled into this, if there's evidence that this was a problem with this particular coach in the past.
Yeah, I mean, I think based on what we know, that certainly if the school district knew, or in the exercise of ordinary care, should have known that this man at prior jobs, at prior districts, or even just at prior camps, had complaints and problems similar to this, you absolutely, I think, have you can make out the elements anyway to plead negligent hiring. We have obviously, I believe, based on what we're seeing, we have negligent supervision, because I think when they should have been providing supervision to this person, obviously the school system has made clear this is not their policy. They would have stopped this had they seen it going on at the time. That means they should be exercising ordinary care in supervising him, which they apparently didn't, because there was nobody, his senior, present. And so that means they didn't watch him right. And then so the other issue is, after they hired him, did they learn things prior to this incident that caused them would have made them conclude it's improper to retain him? So generally, when we're making respondeat superior claims, we're looking for negligent hiring, negligent retention, and negligent supervision. And then we have a whole separate area in which we're conducting an inquiry, and it's whether he was acting in the scope and course of his employment, hired by his, the term of art is master. And so hired by his boss. Was he hired, and in conducting his duties for that boss, did he commit these torts so that, acting as his boss's agent, the agent is responsible? You see that type of argument made many times successfully in bar bouncer cases. And I've worked a number of those cases, and you see, where a bar or nightclub has hired bouncers for security. And those bouncers act overly aggressive. But then you find out that the bar owner's like, I don't want anybody that looks like this coming in here. And bouncers are emboldened and acting in the scope and course of the instructions from their employer. They hurt somebody. And, it sort of reminds me of those bouncers that used to work up there at Hogs and Heifers right outside where you are now. Big, scary guys, and can hurt people real easy.
Well, how could the argument be made that this was somehow not in the scope of employment unless the district had told the coach specifically that he couldn't do it? I mean, he's engaged in the act of coaching, at least in his mind. I mean, that's what it is. It's a team. There's a coach. They're going through exercises. Is there some previous instruction from the district that he's not supposed to do it that way?
Well, if I was representing the school district and trying to defend them, not the coach, but defend the school district, then I would say, listen, we hired this man to exercise ordinary skill in gymnastics and cheer coaching to teach this cheer squad. We didn't hire him to hurt anybody. When he was doing these things that hurt people, he was acting outside the scope of his employment. And it was not reasonable for me or my client to consider that a highly skilled coach is going to persist in conduct that injures his athletes. And so I didn't hire him to hurt these people. I hired him to coach them, not injure them. And, that probably will not get you out on a motion to dismiss or a motion for summary judgment. But it would be a great argument, again, for a Colorado jury to hear.
I could see that going to the jury, because it seems like more of a question for a jury than a question of law, because it's debatable. If it's debatable, then it goes to the jury ultimately. So, here's the bottom line. The coach just said, he apparently is one of the instructors who's seen performing at Denver Bronco games. So he's been involved in this for a long time. He apparently has been unreachable by most of the press, but he told one of the local newspapers, quote, "I would love to tell my story, but I can't say anything else at this time." So he seems to tip a nod to having more to say, but he might be thinking he's got to save it for court.
Well, if this gentleman were to call me and come up with our firm's retainer, the first thing I would tell him is, don't talk to anybody, and don't even tell him no comment, but send any comments or requests for comment to your firm, to your law firm, and we will address that. But you should not say anything. You should not talk to the police. You should not say anything in public about the case, because that will all come back to haunt you, and you shouldn't say anything in private to your friends. Do not talk about it. He is facing criminal charges, and anything he says, as we know, is going to be used against him. So he has to be very careful. He's probably already gotten excellent legal advice to say nothing.
Well, let's switch gears now.
And I don't blame him. I think that's a smart move for him.
I want to switch gears now, Mark, and talk about this other case that we're following out of Utah. And it's a very sad case. There's a young man who's facing the possibility of murder charges related to helping a friend commit suicide, and he recorded it. Where there's a video recording from his cell phone. The judge is apparently mulling over whether or not to let the prosecutor go forward with some kind of a murder charge in this case. The police found out about it when the young man decided to go to them and sort of unburden himself with it, and he made a couple of statements here along the lines of more or less kind of admitting guilt in it. He's saying that, and I'm not sure if I just lost you, Mark, if you can let me know. We did lose him. So, well, we're going to try to get Mark back, as we want to talk about that case out of Utah. And in the meantime, in order to get Mark back, we've got to go into a clip. So let's listen to a little bit more from the case we've been following. That's the John Valerio case out of Nevada. That's a man facing a death penalty retrial of the penalty phase of his conviction. The case happened 31 years ago. The original trial was 29 years ago. Let's listen to some more of the testimony in that case. We'll try to bring Mark back in just a minute.
Good afternoon, ladies and gentlemen of the jury. I wanted to talk to you first and foremost because I wanted to talk to you and look at you and let you hear my voice. And of course, I also thought that if I was sitting in this chair, I would probably want to hear from me. So for those two reasons, I wanted to speak to you. First and foremost, there's not a day that goes by that I'm not remorseful and that I don't think of Miss Blackwell and the things that happened in 1986. I want you to know that. Let's see here. I didn't write a statement because there were a couple of things I wanted to talk about, so please bear with me. My family, Ms. Blackwell and her family were also affected by this, and I want to apologize to them, Ms. Blackwell's friends, my family and friends who have stood by me throughout my incarceration, and I know it hasn't been easy for them. This has been a lot for a lot of people.
Okay, folks, sorry about that. We're back. You were listening to a little bit of John Valerio, who has been a death row inmate for 29 years. He took to the witness stand himself and gave what's called an allocution to the jury. He was not questioned, he was not under oath, but it gives an inmate the chance to talk to a jury, in essence, to try to save his own life. We'll be back with more analysis of that case in a bit, but Mark Tate is back with us from Savannah, Georgia here. Mark, we wanted to talk a little bit about this case from Utah. It's a horribly sad case. A young man facing the possibility of murder charges related to a recording he made of a friend committing suicide, and a judge is reviewing it. So from a threshold inquiry, first of all, you've got a recording. Second of all, you have what sort of kind of amounts to a confession, as I understand it.
Yeah, that was my understanding as well. I have a hard time seeing murder in the case. I see, some sort of homicide, but murder carries with it a much different standard of proof. And the girl did take steps that ended her own life, but again, it's sort of the mores of the community in Utah, and I think that Utah is overwhelmingly Mormon. I think this is the kind of thing that's outrageous. I think it's the kind of thing that will utterly infuriate a prosecutor, and I think that I think the guy will probably be indicted for murder. The questions I have, though, would be, and if I was looking at the case, I would want to know how the police got the telephone. Generally, you can't just grab somebody's phone and go through it because they've told you somebody has passed away.
I think that he went to the
that's
police.
going to be interesting.
I think that he went to the police, Mark, and showed them the video. Is the version of it that I read from it.
Yeah, well, if he showed it to him, then his goose is cooked. But I think that at least one of the accounts that I read was that the police went through the phone. And just because you're in a police station doesn't mean they can grab your stuff and go through it. I would want to understand very carefully exactly how they got a hold of that evidence, and I just don't understand that right now.
Yeah, I'm trying to understand how it all happened. You may have keyed onto something that maybe I didn't pick up on, and I'm going back through my original notes on this. Apparently, my version of it is that the defendant to be here, it seems, showed police the phone, and that's what I took away from it. I'm not sure. Maybe you read an article that was worded a little bit differently than I did, but what we're talking about is a really important legal distinction here. Bottom line is, if he volunteered the video to the police and said, "Here, watch this, I feel bad about it," well, there's not a search and seizure issue there. That's constitutional. If you go up to the police and say, "Here's evidence that I may have committed a crime," they can use that against you. Mm-hmm. However, if the police just start going through the phone, then that's a different issue, because unless they've got reasonable suspicion piling up to probable cause, then they can't search your house's papers, persons, or effects. A phone is an effect.
Right.
At least unless they get a warrant, and I don't think they did here.
No. I don't think, I just don't know. But I think a good lawyer defending this guy would absolutely need to pursue that and understand the nature of the circumstances under which the police got a hold of that evidence. But when you start looking at the elements of what he can be charged with, he knew apparently the consequences of his actions. He knew what was going to happen. He provided the means, the tool to accomplish that death. And he knew, based upon the conduct that he was engaging in, that it would result in someone's death. And I think if you look at just the general, criminal law elements of murder or intentional homicide of some level, some degree of murder, I believe that you can weave together the elements of a charge to be made against him. I don't know in Utah if it's going to be first-degree murder, if it's what it's going to be. But we know that by the facts we know of the case, regardless of whether the evidence is ultimately admissible, Aaron, that he engaged in conduct knowing that it's going to result in someone's death. Just no doubt about it. I'll also add that the kid is obviously, and I say kid, I shouldn't say that, but this fella, Presbowicz, he doesn't give off the appearance of an erudite, sophisticated, educated person. He looks to me like somebody who probably has a significant history himself. And that's just a very stereotypical, just looking at the way he seems to carry himself and the way he looks, I would not be surprised to learn that he has a mental health history as well.
Well, we'll leave that to be seen because we don't know, and I don't want to speculate. But at a minimum here, there's evidence on the record that he's certainly troubled. He apparently told police he had a, quote, fascination with death. And the prosecutor is going after this murder charge because apparently not only did this young man supply the rope that the poor girl used to kill herself, but also had researched methods of suicide and then shared a lot of that with her. Yeah. And, there's another weird element of this wrapped up too, where apparently he had made a suicide pact with her. and said, well, if you kill yourself, I'll kill myself, and he never really had any intention of doing it himself.
Yeah, that was really more like a suicide fraud. I don't know. That seems like a bad deal to cut on both sides. So that certainly is a nasty position to take with someone. And I don't think it's indicative of somebody who is sitting on sound footing, mental footing. But we also, I believe, have learned that he was aware that she had had other issues in the past and was on psychiatric medication. And I think he knows enough to where the community standards and I think the Utah Criminal Code is going to support him being criminally disciplined for this. At what level? I don't know. It's hard to know. I think a prosecutor should be careful and not overcharge somebody like this, because once you go after him, you want to make sure that he's convicted. And there have been many instances when prosecutors take a set of facts and charge something without charging lesser included offenses, and they wind up seeing a culpable, at some level, criminal defendant walk away unscathed, when really, had they been more narrowly charged, that person would be doing appropriate time. Is this young man going to get a life sentence because of what he did? That really doesn't seem likely. We have a recent example that you did an excellent job reporting, the young lady who texted her boyfriend to death.
This thing has so many shadows of that Michelle Carter case, and this one, we've got a guy who planned the whole thing out with the victim, bought the rope, also bought an aerosol can that she was inhaling the fumes of as part of this thing. He drove her there, he filmed her, and he encouraged it. But I've got the same question that you do, Mark, and that's, does that make murder, or does that make something lower down the chain? The prosecutor, I believe, was the one who wrote somewhere in the court records that, it's like getting away with murder, but that seems a little bit loose with the lips, because murder is usually premeditated or heat of the moment or something. I mean, maybe, some kind of manslaughter or something further down the chain might potentially be a charge that I would have a better ability to stomach in this case, but a top charge here, a murder charge, and I don't know what degree they're alleging, because I don't have the court records in front of me, but it's, I don't know about that, so I tend to share your trepidation about it.
Mm-hmm. Again, the kid needs to be punished for what he did. It shows, just from my standpoint, it seems to show such a depravity of spirit and heart, to not only take someone who is mentally fragile, but then add to that, giving them a substance, the aerosol that's going to change their mentation, and providing them the tools to cause their own death, knowing that they have issues, but then recording it, and that that's like making snuff films. That's just that shows that there's something deeper here, and maybe incarceration is the answer. Maybe again, a skilled, well-compensated criminal defense lawyer would be able to have him mentally evaluated, and he can be found, guilty, but mentally ill, and rather than doing time in prison, maybe his time is served, getting mental health help. I don't know. But this is not conduct that should go unexamined and uncharged. But I think, like I said, I think in order to make sure justice is done for this poor girl who passed away, I really do think that they need to have a prosecutor who is attuned and understanding exactly what all should be charged. But I think this young man is going to need an excellent criminal defense lawyer and make sure the right thing happens to him.
Yeah, I'm getting some information from Kathy Rustin, who's our senior trial producer here, Mark, and maybe we can try to at least inject this factual debate into things here. I don't know if we can settle it. One of the reports I read seemed to suggest that the actual footage, the disturbing footage of the actual suicide attempt was on a phone that this possible defendant handed to police, but Kathy's got some information that says that it was actually on the victim's phone, and that the victim's phone was found in a bag with her suicide note somewhere. So I'm a bit confused by where the phone actually came from, but if it was found in a bag left behind, then I don't see a search and seizure issue jumping out at me. So,
Absolutely not.
You know, and it may just be that some of the reports that I'm reading are getting their wires crossed, but you know, it's a factual discrepancy that we're going to have to get cleared up at some point. That's a little bit unclear from what we know sitting here.
Well, you know what's great about getting these little pieces of information, though, Aaron, and having the opportunity to discuss it, is because it provides anybody who's watching your show with, I think, an interesting window into how lawyers, whether they're civil or criminal lawyers or defense lawyers or prosecutors, kind of analyze little pieces of evidence and have to really track down a lot of evidence and digest it and analyze it in the face of the law to determine how it's going to come out. So it provides an interesting analytical tools.
Yeah, well, we're going to wrap things up, Mark. Mark Tate, trial attorney, Savannah, Georgia, dressed in the Savannah style on LawNewz today. Hey, it works. Go with it. Good to see you on LawNewz, Mark. We'll have you back sometime soon.
Thank you, Aaron. It was a pleasure.
All right, have a good one.